Hi everyone, welcome to the Legal Leverage podcast. This is the podcast for founders, entrepreneurs and growing businesses who want to understand how legal decisions can shape the success or the failure of their company. I'm Babs, I'm a corporate and commercial solicitor and I'm one of the founding partners of Jamieson Law. We advise SMEs, founders and scaling businesses on everything from investments and acquisitions to commercial contracts, employment law, trademarks and commercial property leases. One of the things that I see every day in my work is that the legal side of running a business is often misunderstood or ignored until something goes wrong. So on this podcast, we break down the legal issues that actually matter to founders in a way that's practical, accessible, and commercially focused. Before we get into today's episode, I should say it's been a while since the last episode of this podcast. I'm really pleased to be bringing the podcast back. There's been so much happening in the legal and business world, particularly right now, that founders really need to understand. So it felt like a really good time to bring it back. So if you're new here, welcome. We're delighted to have you. And you've been listening on and off for a while. Thanks for sticking around. We really appreciate it. So with all that being said, let's dive into today's episode. So let me start with a question. If you employ people in the UK today, how confident are you that your employment contracts, your policies, your internal procedures will still work in 2 years' time? Because the reality is that the employment law landscape in the UK is about to change quite dramatically. Over the next 2 years, the new government is rolling out one of the biggest employment law reforms that we've seen in decades. And some of these changes are technical, as they always are with legal changes, but some of them are genuinely very significant and they will change your risk profile as an organisation. So we're talking about things like unfair dismissal protection after 6 months instead of 2 years. That is the big one. Sick pay payable from day one, new liability for harassment from customers or clients, and potentially much greater protection for workers on 0-hour contracts. There's a lot of change there. If you're a large corporate with an HR department of 20 people, that's one thing. But if you're running a growing business, these changes can really affect how you hire, how you manage, and sometimes how you dismiss staff. So today I want to talk to you about what's actually changing, but more importantly, what it means in real life for real business owners. Because legislation on its own doesn't change much, but what matters is how it plays out in practice, in day to day. So the first thing I want to talk about is the biggest mistake that I see growing businesses make when it comes to employment law compliance generally, even before these rules took effect. So one of the things we see all the time when advising businesses is that employment law tends to sit quite low on the priority list. That's not because founders don't care. It's because when you're building a business, you're focusing on customers, you're focusing on revenue, product, growth. Employment documentation often gets written once and then it's forgotten about. And the funny thing is that approach can work for quite a long time until something goes wrong. And then when something goes wrong, there's a grievance, there's a dismissal, there's a discrimination complaint. The first thing your lawyer or the tribunal is going to ask you is, what did the contract say? What policy did you follow? And unfortunately, very often the answer is, oh, we don't actually have one, or we downloaded it from the internet 5 years ago. So before we even get into the new legislation today, guys, there's a bigger point here. Employment law works best when it's boringly organised before you actually need it. Because once there's a dispute, it's usually too late to fix the foundations. And I cannot tell you how many times I've been on calls with people and what they're, employers, founders, what they're proposing is really reasonable and how they've acted is really reasonable. But because they don't have proper documentation in place, their legal rights are really, really limited. So let's talk about some of the changes that are already happening. So the Employment Rights Act has already started to bring in some new employment law changes. A lot of these relate to trade union rights and strike protections. For many SMEs, that's probably not something that's going to affect your day-to-day operations, but it does show the direction of travel. It's the new Labour government. Labour government is always going to be more protective of employees' rights. So it shows where we're going. The current policy direction is very clearly geared towards greater protection for employees and workers, and that becomes a lot more obvious when we get into the changes that are starting to take effect from April this year, so April 2026. So what are we talking about for this year? Well, there are several key reforms that are going to affect many employers from April. So let's start with statutory sick pay. Right now, if someone is off sick, SSP only starts from day 4 of the illness. So the first 3 days are known as waiting days. And from April 2026, SSP will be payable from day one. So that might not sound significant, but for employers with large workforces, particularly sectors like hospitality, retail, it could really increase short-term sickness costs. We also all have dealt with those employees that don't come in on a Monday because of a hangover, or they're calling in sick too often. They would have entitlement to statutory sick pay for those days. It wouldn't be unpaid. So it might not sound huge, but there's other significant changes coming along as well. Like currently employees have to earn above a certain threshold to qualify for statutory sick pay, but that lower earnings limit is going to be removed. So that means many more workers are going to be eligible. It means that businesses really should be reviewing their sick pay policies and their contracts now and understanding how much they're likely to be on the hook for, and making sure that they have a really great workforce that isn't just calling in sick at the drop of a hat. That might not sound politically correct, it might not sound great, but that is what the kind of thing under this new employment legislation that could really cripple a business. Something to think about. Another change that is coming in April 2026, it relates to parental rights. So both paternity leave and parental leave will become day one rights. Previously, employees usually had to work for a period of time before qualifying. Now those rights exist from the very start of employment. So you could hire someone today and tomorrow they're entitled to paternity leave. That also reflects a wider policy shift that we're seeing under the new laws. The idea is that family-related rights should apply immediately. None of this, guys, is to imply that it's not important to protect these rights with employees and that we don't want to do the right thing by our employees. But the problem is all of this results in significantly increased costs for employers and a lot more obligations, which is really difficult for a founder of a growing business when you've got everything else to manage and pay and organise. There's then also from April an expansion of whistleblowing protections. So sexual harassment will become a disqualifying disclosure under whistleblowing law. So that means that employees who raise harassment concerns would gain whistleblower protection. That's very important because whistleblowing claims can be very serious for employers. And it means that employees cannot be discriminated against or treated badly because they have made such a claim. Another area that businesses should be keeping an eye on in the coming weeks is gender pay gap and menopause action plans. So from April 26, these are going to be voluntary, but the expectation is that they will become mandatory during 2027. So for larger employees in particular, it'll mean as well that they'll need to do more structured reporting and policy planning. From October 26th, so the first one we've spoken about there is April 26th. That's the changes we just mentioned. Then from October 26th, there's going to be changes to the law of harassment. This is really interesting. Employers will become liable for harassment that is committed by third parties. So not harassment committed by employees that they employ, but harassment by customers, clients, contractors. So you want to be thinking about industries like hospitality, retail, professional services. Imagine a client behaving inappropriately towards an employee. Under the new law, the employer could actually be liable for that harassment unless they can show they took all reasonable steps to prevent it. And that all reasonable steps wording is very important. Under harassment law, currently, the bar is reasonable steps. And that might not seem like a significant change, but all reasonable steps means that the business has to have taken all reasonable steps, funnily enough, that they should have taken to prevent the harassment. So businesses will need to demonstrate things like training, policies, reporting systems, and action when issues arise. There are also changes expected around NDAs, non-disclosure agreements. New rules are likely to make those clauses unenforceable if they try to prevent workers from disclosing harassment or discrimination, which is really interesting. We've all seen that in TV shows about employers who pay an employee off if they sign an NDA and don't mention about some sort of discrimination or harassment. That's going to become illegal under the law. That also reflects a growing concern around confidentiality agreements being used to silence workplace issues. So that's the reason for that change. Another really important change, this is significant for most founders, is that the tribunal time limits will increase from 3 months to 6 months. So that effectively doubles the time that employees have to bring claims. A lot of the time, if we're advising founders and it's, oh, well, this happened 2 months ago, we're saying to them, you really only have another kind of 4 weeks to wait to see if there's a claim. After that, the employee is time barred. That's going to become much longer, which increases your liability period. Obviously, it doubles it. So for employers, it can really mean that disputes can remain legally live for much longer. Then the next big change timescale is January 27 that we want to talk about. So let's talk about what's probably the most impactful change for many businesses. I mentioned it at the start. From the 1st of January 2027, protection from unfair dismissal will apply after 6 months of employment. So currently it's 2 years. It's 2 years in the UK, it's 1 year in Ireland. Ireland has always been seen as much stricter and more difficult to hire and fire employees because of this 1 year period. In the UK, it's going to become 6 months. That's a huge shift. Why? Well, because many businesses treat the first year or two of employment as kind of an important formal probation period. So if things aren't working out, the employer can part ways relatively easily, unless there's like a discrimination issue or a protected characteristic or something like that. Generally speaking, an employer would just terminate the contract with notice up to 2 years, and they don't need to go through a full fair process to doing so. Reducing that period to 6 months means that businesses will need much more structured probation processes, and they will need to make sure that they're much clearer on things like performance management, properly documenting why they've got rid of people, justification, the process they've followed, etc. Businesses are going to need things like regular review meetings, documented feedback, and clear expectations. Because if an employee reaches 6 months and is then dismissed, they then may have the right to bring an unfair dismissal claim, which is a real problem for many, many employers. We've another change as well, a major change from January, and that is that the reforms are removing the cap on unfair dismissal compensation. So at the moment, you can only bring an unfair dismissal claim if you've been employed for 2 years minimum, and there is a cap. There's now no cap, and you can bring it after 6 months. Again, we're talking about significantly increasing your potential liability, your potential risk threshold, and the potential money that you're going to be out as a founder if something goes wrong with employment. Finally, there's a big shift around fire and rehire. That's where employers dismiss staff and offer them new contracts with worse terms. Under the new law, in most situations, that will just be automatically unfair dismissal. So what about some of the other changes that are still coming? We've spoken about April 26, October 26, and then January 27. Those are the confirmed dates and the confirmed reforms, but there will be some additional changes expected during 2027. These include stronger maternity protections, statutory bereavement leave, rights for 0 hours workers to request guaranteed hours, compensation if shifts are cancelled, requirements for reasonable notice of shift changes as well. These reforms are going to be particularly significant for industries that rely on flexible labour models, hotels, restaurants, that kind of thing. If there's one takeaway from all of this, it's that employment law is becoming more structured and more protective of workers in general. For employers, the key question isn't just what does the law say, it's are our systems good enough to handle it? Most businesses won't need to completely rewrite their employment contracts and their handbooks, but they will need to update contracts, handbooks, harassment policies, sick pay policies, and probation procedures, and they should do so. Doing so now is very preventative. It is a great idea from a risk-based perspective, and it will cost less in the long term. Because employment disputes are rarely arising from the law itself, they arise from how the business is managing the people day to day. If you would like our help reviewing your employment documentation or understanding how these reforms will affect your business, please feel free to get in touch with us. Our email address is info@jamiesonlaw.legal, or you can find us on our website at jamiesonlaw.legal. If you've enjoyed this episode, please do follow the podcast, share it with someone who might find it useful, and leave a review wherever you're listening. It genuinely helps more founders and business owners discover the podcast and learn about their legal obligations in hopefully a not too boring way. And if there's a topic you'd like me to cover in a future episode or a different format you'd prefer, I'm really open to feedback, so please feel free to get in touch. Again, it's info@jamiesonlaw.legal. Thank you all so much for listening. It's great to be back, and I will see you in the next episode of the Legal Leverage Podcast. Take care.